knows his stuff, and I think he'll come out of this with a lot of new information, maybe a few things to make you a little nervous.
Or you might just be disappointed at the end.
I'm going to say no. You won't be disappointed. There is a sign-up sheet in the back, but when we're getting started here, I'll go ahead and start passing that around, and you will be emailed your certificate probably within the next 24, 30 hours, something like that. All right. Anyway, thank you. Take it away, Kevin.
Thank you, Tootie. I do about one of these classes a week, sometimes two. And I started them because of Tootie. About 4 years ago, I did a class for her. And then I just kept doing them and doing them. I don't get paid either. And apparently some speakers get paid. So we need to talk about that too. But here's what we'll cover today. Your obligations and duties as a realtor, common claims. Talk about several actual cases involving lawsuits against brokers. And then we'll also talk about probably the most important thing, which is insurance coverage. In other words, what protects you in the event that you do get sued. And one important thing to remember is anyone can sue anyone for anything, and it happens frequently. And frankly, a lot of buyers, if they sue a seller, the buyer's lawyer generally knows that you guys have errors and omissions insurance, and so brokers get looped into these lawsuits frequently, even though the broker didn't do anything wrong. And it's a terrible process to have to go through, but it happens. Now, let me start at the beginning here. Back in the old days, you could sell anything you wanted, even if it was on the verge of collapsing and it wasn't obvious. And that doctrine was called caveat emptor, meaning let the buyer beware. So before about 1950, 1960s, that was the law in most states in the United States. You didn't have to disclose anything. You didn't have to tell a prospective buyer about any problems. And then that all changed in about the 1950s because legislatures across the country started adopting statutory disclosures. And you know who pushed for that in every state? Realtors. You've heard me see. You've heard me. No, you haven't. Okay. I've seen you at a. So by the way, if you've been to one of my classes, I recycle a lot of my jokes. So just laugh even if you've heard it before. Okay.
Kevin, we love you.
Okay, good. Now. There's a laundry list of duties that you have as a broker in Oregon, and they're all outlined in ORS Chapter 696. And here are some of the big ones. One, present all offers, even ridiculous offers. So if you've got a listing and it's listed at $500,000 and someone comes to you and says, you know what, I'll buy it for $200,000, and you think that's just ridiculous, ethically and legally, you still have an obligation to convey that to your client. Sometimes clients will take ridiculous offers, and that's their choice to make. Now, there's one additional requirement in Oregon, and that is if your seller is already under contract, they've signed an agreement, there's a closing date scheduled, and let's say a buyer comes out of the woodwork and offers $50,000 more. What are your obligations at that point? Seller's already got a contract executed, closing date scheduled. Do you need to tell the seller about this new offer? Yes. Present all offers. And in Oregon, as you convey that offer, your other obligation is to tell them to talk to a lawyer, because they're about to break the contract, and they'll probably get sued. But some sellers will do that. If the legal fees are $20,000 and the new offer is $50,000, a lot of sellers will break that contract and they'll come out ahead still. So, but again, that's their choice to make. Act with diligence, account for money received. Any of your brokerages use a trust account? Very few still use those. That's probably the number one reason that brokers are disciplined in Oregon. And also, by far, the number one reason lawyers are disciplined is mismanagement of trust fund money. And there's an ethics case that the National Association of Realtors publishes, actual ethical complaints, the facts, and then the outcome. And there was one a while back where the broker put the client's money in the trust account, borrowed $200 and paid it back in an hour. Is that an ethical violation? Yeah, you can't borrow, even if you pay it back really quickly. Another one, disclose conflicts. And conflicts, there's usually a difference between a legal conflict and what your client's, as long as he discloses it. Generally, now, if Alan doesn't receive a financial benefit, technically it's not a true conflict. But, again, what your clients think is a conflict and what legally is a conflict are different. So always err on the side of informed consent and disclosure. And a lot of things that brokers get either sued for or ethical violations for wouldn't be if there was informed consent. I'm going to turn the mic on. Paul says. Can you hear me?
Oh, yeah.
Turn it up a little bit. Turn it up? You're joking. Okay. Is this better for the recording? Okay. I feel like I need to lead an aerobics class right now. You know, or Tony Robbins, yeah. And then lastly, refer folks to experts when necessary. If you don't know anything about the tax consequences of a transaction, don't make something up. Tell them to go talk to an accountant. It's that easy. Now, a lot of these duties boil down to what are called fiduciary duties. You ever heard that term before? What does it mean?
Protect your money.
Yeah.
Well, you represent the client.
Yeah.
So anything you do has to be in their interest.
But the first thing you said is spot on. It's a fiduciary is generally someone who has control or influence over someone else's money. So lawyers are fiduciaries, board members of corporations are fiduciaries, your accountant or investment banker is a fiduciary, and you, as a broker, are a fiduciary. So that means you have to put your client's interests ahead of yours, even if it means that your self-interests are defeated. So if you learn of a material fact that you know as soon as you tell your client it's going to cause the deal to fall through and you lose your commission, well, your fiduciary obligation is to tell your client that material fact. Speaking of which, you also have a duty to disclose material facts to your clients and sometimes to the public. What's a material fact? Anything.
It has to do with the real property.
It has to do. What about? Yeah, that's where you were going. Yeah, and so the problem is, a lot of times material facts are subjective, and that's where it gets tricky.
What your buyer thinks is a material
Exactly.
fact.
Exactly. I'll give you some examples of material facts. So I represented, it was actually a broker. It was up in the Seattle area, and the seller had listed a property. The buyers were Indonesian, hadn't seen it. They flew to Seattle to look at it, and as they're driving there, they realized there's a cemetery 3 blocks away. Yeah. And I didn't know this about Indonesian culture, but apparently that's very, very taboo. Some of you knew this. I asked about 100 people about whether or not they knew that in Indonesian culture that living near a cemetery is taboo. So that's material to these particular clients. Most other folks, it's probably not material. I frequently talk about a case in upstate New York where this lady finds her dream home. She tells the realtor 3 different times that part of the reason it's her dream home is that because of these giant concrete garden gnomes in the front yard. And so, what's that? Which, yeah, but yeah, we'll get to that in a second. So the broker doesn't think much of it. They're just concrete garden gnomes. And anyway, they were gone after closing, and so she sues the broker. The court says, if the client tells you 2, let alone 3 times the importance of something, it's material and it needs to be in the contract. Now, you brought up a good point that it's personal property. What defines personal property versus a fixture?
It's not attached.
It's not attached. Okay.
So cause damage to.
If you take it out. So my dishwasher, I installed it myself a couple years ago. I shouldn't have. I unscrewed the wrong hose. But I fixed that. But anyway, there's a little screw on the underside that goes into the top of the counter. I can pull it out with my finger. Is that a fixture?
Yeah.
Yes. Why?
Because it's perceived as being built in.
Oh, so it's a perception, perhaps. What about a hot tub?
That's negotiable.
Has to be attached.
Has to be part of the contract. Does it have stone? All you have to do is write it in.
Agreed. That's the short answer. Write it in if there's a question. And I'll tell you, there's really no good definition of a fixture. Some folks say hot tub is, other folks say no. Usually when I talk about the dishwasher, people say, well, it's a fixture because it's connected to the water line. And then I say, what about a hot tub? And they say, not a fixture. I say, well, it's connected to the water line. So there's just no good definition. If you want it to be part of the deal, put it in the contract.
People want it carried away, so you really have to
Yeah.
write in taking it with you.
Yeah, well, one other thing, the photographs that you guys use in the MLS system, those are representations.
Yeah.
So if you have a photograph in the MLS listing showing a hot tub, and the hot tub's gone, and the contract doesn't address it, that's a misrepresentation. And if you're the one that put it on the MLS, you'll probably get sued. How much are hot tubs? A few thousand. So, expensive. Yeah. Now,
Depends if you buy them a used one.
that's true. That's true.
Always thinking.
That's right. Now, contracts get brokers into trouble occasionally, and it's usually when certain parts of the deal aren't put in the contract. And so, all contracts have four components: offer, acceptance, mutual assent, and consideration. And where things get tricky is when brokers start writing contingencies that aren't standard or customary, and they mess it up. And I think I might have an example. I'll show you an example in a second. But again, you know what this means? Statute of frauds. Have you ever heard that? It's on the real estate exam, I've been told. Yeah, it means in writing. So a lot of contracts, oral contracts, are binding. They can be. If I say to Alan, I'll give you $20 if you refill my coffee, and he gets up and refills it, I don't pay him, he could sue me, and he'd win $20. He's got a lot of witnesses. But the courts have said over the last many years, certain agreements are so important that they have to be in writing to be enforceable, and that's called the statute of frauds. So leases for more than a year have to be in writing. What else? The sale of anything involving the sale of real estate has to be in writing. Easements have to be in writing generally. Prenuptial agreements. Any of you getting married soon? No? Prenups have to be in writing. Now, it's pretty easy to satisfy the writing requirement. You can get a crayon and a napkin and just write it down. Electronically, you can sign things now. Most of you use DocuSign. Do you know what great American president you have to thank for your ability to use electronic signatures? It's kind of a joke, but not really. President Clinton. No, really, you have him to thank. He signed into law the Federal Electronic Signature Act, so that's why you can DocuSign. And I was joking. I don't know if he's the greatest or not. I'm not political. Now, let me give you an example. And I know you might not be able to see this. This is a contingency that a broker wrote. And it says, seller to contribute up to $5,000 of buyer's closing costs and or prepaids. What's the problem with the way that's written? If the seller contributes $1, they've complied with that. That's not what she meant. What I think she meant is seller to pay all closing costs up to $5,000. And that's very different than what she's written. I do a class on contingencies. This is a good friend of mine. She'd kill me if she knew that I went through her files and pulled out problematic contingencies. But I always say, to avoid issues, one, either if you've got access to a lawyer, have a lawyer write it. If not, have a non-broker, someone that's not associated with the transaction, read it and ask what they think it means to them, because sometimes you'd be surprised. And a lot of times, this is language that brokers write frequently and just don't think about what it actually means. But if a lawsuit arose over this, it goes to arbitration, and the arbitrator would look at it, and whatever the plain meaning is what it means. And to me, it means if you contribute $1, you've complied. So just be careful with how you write things in that aren't traditional or common in those types of agreements. Now, the most common reason that brokers get sued by far is for misrepresentation. So here's what a party has to prove against you to recover. They have to show that you knew or should have known that whatever you said was wrong. It was material. You intended them to rely on the statement. They did rely on it, and they were damaged as a result. Now, the knew or should have known, that's a pretty high standard. So a lot of things in the law, it's you knew, not should have known, but it should have known. So you're judged on the standard of a licensed real estate broker in the state of Oregon is the standard of care that you have to exercise. Now, it has to be material. If you make a misrepresentation about something that's not material, there's no claim for misrepresentation. It doesn't mean you're not going to get sued. It just means there's going to be a year-long process where your lawyer gets you out of the lawsuit because there's no claim there. Now, there's two types of misrepresentation. The most common is what's called negligent misrepresentation. You made a mistake. You weren't intending to lie. You just said something and you were wrong. And that's what insurance protects, is negligence. Your car insurance protects you against negligent acts. If you intentionally run someone over, that's intentional. There's probably no insurance for it. It's true with car insurance. It's true with E&O insurance. The other type of misrepresentation, the bad kind, is where you intend to lie. And that's also known as fraud. Have you ever looked at your E&O insurance policy? No one? Maybe you should. Well, make sure you have one. What's that?
We don't probably read any insurance policies, right?
Most people don't. But if you ever do, the first page is everything that's covered, and then the next 80 pages are all the exclusions to what they just said they were going to cover. And one of the most common exclusions is fraud. So if you get sued for fraud, you may not have insurance coverage for that. We'll talk more about insurance in just a little bit. I'm going to skip through some of these. Material. So the best definition I found of what's a material fact is it likely to affect the party's decision. So, you know, a hairline crack in the door frame might be material to some folks, might not be to others. It just depends. It's subjective. Now, as far as reliance, so that third or fourth element of misrepresentation claim, they have to show that they relied on whatever you said. Now, here's an important point. The courts have said, well, people don't have the right to rely on things that you express as an opinion. But the problem is that if it's your client, whatever you say, they don't hear an opinion. You're the expert. They hear a fact, even if you say the word opinion. So if you were ever in a situation where you were truly trying to express an opinion, let's say they come to you and say, you know, what's the square footage of the house? You say, well, according to the assessor's website or whatever, I think it's blah, blah, blah. That's an opinion, but your client's not going to hear it as an opinion. They're going to hear whatever square footage you said is the truth. So if you're ever wanting to express it, follow it up in writing and use the word opinion to protect yourself. And the other piece, to their detriment. So they had to rely on it, and then to their detriment. Now with damages in misrepresentation cases, sometimes they're pretty easy. So the misrepresentation caused the sale to fall through. The buyer had to find a new house. There was an extra $30,000 in the same area. The damages are $30,000. And you can also sue for what's called specific performance. So misrepresentation occurred, the value of the property is less, but you still want it. You can get an arbitrator or a judge to say, seller, you must sell the property. And that's one of the few areas of the law where you can sue not just for money, but for specific performance. Someone has to do something. Now, when it comes to misrepresentations, there are a lot of court cases that have said, you know, buyer, if you waived your inspection, you've waived your right to any misrepresentation claim. And I'll talk about a case in just a little bit involving that. So if you ever have a client that says, hey, I want to waive my inspection, in writing, tell them that's a terrible idea. Because if there is another a legitimate misrepresentation, they've waived their inspection, they might not be able to recover at all. So don't ever let your buyers waive that. And if they do, put it in writing that you think is a terrible idea. Now let's talk about common misrepresentations. Most of the cases involve brokers misrepresenting the size or boundary of a parcel. Now, when you get a title report, you usually get an assessor's map. It looks something like this, and then whatever parcel you're dealing with is highlighted. You know what I'm talking about?
Yeah.
What's that?
Star on it.
Yeah, it usually has a star. Now, you don't have a right to rely on an assessor's map for anything except the assessor's number. So most of the time, these boundaries will match up. Not always. But here's an example. This is the same subdivision. This is the plat. So here you see that there's a sewer easement that runs the entire length of that lot. There's an access easement right here. Common property here. Sewer easement here. None of that is on the assessor's map. So again, don't use the assessor's map for anything. It's a quick way to visualize where the property is on the title report. But as far as substantive information, don't ever use it. Just get the plat. Make sense? Yeah. Okay. You know what kind of legal description this is called? Also on the real estate exam. Meets and bounds. Yeah. I'm trying to remember why I put this in here. I know why. This is kind of fun. And so let's start. start here. So, Section 25, Township 1 South, Range 1 East, Willamette Meridian. So, you know you're in one of two states if it's off the Willamette Meridian, right? Oregon or Washington. Do you know where the Willamette Meridian is?
It's up on the sky.
Yeah, it's beautiful. I take my kids up there, they hate it. Why do we need to see this? Why? Because every piece of property in Oregon and Washington is based off this 2-foot monument. My dad's a surveyor also, that's why I like it. Your dad's a surveyor? In Oregon?
Until he died last summer at 107.
Wow.
Wow, that's incredible.
That's impressive. Wow. Well, so you might not know all of my trivia questions then. So here, this is a transaction I dealt with just a couple of summers ago in Clackamas County. So beginning at point 9.38 chain south, 7.5 chains east. Do you know how long a surveyor's chain is?
I don't know. I can't remember. I used to hold them, but
Any guesses? You were off.
37.5 feet.
Definitely wrong.
Seemed very specific.
They're 66 feet.
Okay.
Did you say why?
Yeah.
Ah, now that's a great question. And I think I kind of have the answer. So chains are based off a surveyor's rod, which is 12 feet. Now your question is, where does that come from? And I figured this out. It may or may not be true. There's a little notation in this treatise from 100 years ago that says the surveyor's rod was the distance of the left feet of a row of priests in an Anglican church.
You know, that's not too far off. A lot of our stuff
Comes from that weird stuff, yeah. But then I come to find out there was a company that made rulers and measuring tapes in New Jersey in the 1800s, and they published comic books on measuring. That's where it comes from, the Anglican Church. So it may or may not be true. And I've been trying to find that comic book. They're obviously out of print. They're like $1,000.
That was Charles Schultz's great-grandfather.
Yeah, nice try. Could have been. So back to this. So do you know, surveyors don't use chains anymore. They haven't for many, many years. But you know what happens to metal on hot days? And on cold days, it contracts. So if you ever see a legal description measured in chains, if it's a large parcel, it could be off by feet, sometimes acres, if it's a chain, if it's measured in chains. So anytime and here's why this is important. If I own an 80-acre parcel zoned exclusive farm use in Washington County, I can probably build one house. If it's 79.9, I can't. So that 0.1 acre is critical. That will dictate whether I can build a house. And so if you come across a legal description like this and it's large, tell them to get it resurveyed. It's worth the cold day. What's on a cold day? Yeah. No, surveyors now, they don't use any of that stuff. It's a one-man crew now with satellite and everything else. Now I'm going to start with the first case, and I'm going to pull up my notes because it's a pretty fascinating case. And I'm going to read you the facts. Husband plaintiff was the child of Russian peasants who fled the 1917 Russian Revolution for Korea. Already exciting, isn't it? Gets better. He and his wife were born in Korea, but despite the fact were legally regarded as stateless persons, they are not allowed to own property. Eventually, they settle in California and buy a home in San Mateo County. When they sold that home and were ready to invest, they decided to buy property big enough so that it could eventually be subdivided into 2 lots, one for their son, one for their daughter. They did not want them or their children to ever be landless again. They tell this to broker David Segal, who works with Coldwell Banker, when they solicited his help to find a house in Hillsborough, California. He explained how the subdivision process worked and indicated they would need at least a 1-acre site in order to subdivide it. He says they're rare, but be patient. A few weeks later, Segal comes across a listing in his own office, and it reads, quote, house on 1 acre plus, end quote. Not plus, minus, plus. The listing agent was Betty Cruz. She got the idea the property was of 1 acre or more from the sellers. The property was fenced, and the area within the fence was, in fact, more than 1 acre. Plaintiffs bought it for $274,000 in 1979. To make a long story short, many years later, some new neighbors to the south buy, and they tear down the fence and start rebuilding it on the true property line, which made the plaintiff's parcel less than 1 acre. So it goes to trial. And had it have been subdividable, it'd be worth $1.1 million. Because it was not, the difference in damages was $274,000. And guess who paid? Seagal, the broker. Not the listing agent. No, that was the original broker.
No, but the listing agent.
Listing agent got out. Listing agent no liability, and here's why. The court said listing agent didn't have any fiduciary obligations to them. Even though they're in the same office, that fiduciary obligation runs to the individual agent, not the whole office. And so Seagal's E&O carrier ends up paying close to $300,000.
Was that fence up for longer than 10 years?
Yeah.
Notorious use?
Everyone always asks,
That's
well,
a
did
big
they have
deal.
an adverse possession claim? And the answer is the court, I don't know. Court cases don't always give you all the facts.
So
what
They
about
sued.
if they did the survey before the buyer bought the
They
property?
didn't.
Would that would
That would, yes, that would have solved it, because they would have had it surveyed, and the surveyor would have come back and said it's just shy of the total, the 1 acre that's subdividable.
If he had suggested that they do a survey and they said, no, we don't want to.
Then probably no liability, yeah. If they don't take your advice and they get injured as a result, that's on them.
Right, all you have to do is put it in writing.
In writing, yes.
Email.
Yeah, but how many people survey a property that's fenced?
Not many.
Well,
I agree.
actually,
You should.
But-
both fences on my
But
property.
here's the distinction. You're right. Most people don't. But here's the distinction. If your client comes to you and says, "I like this property," and they tell you of their intent to subdivide it down the road, that's when the red flag should go off and say, "We better make sure it is subdividable." But yeah, you're right. Generally speaking, you're not getting into a survey. But if the size is critical to what you can ultimately do, definitely important. Yes, ma'am.
So would contacting the county or whoever would have that might not be enough?
Might not be, because sometimes the county's acreage or size is off too. Historically, it could be up. They might be using the same bad data for 50 years. Okay, I'm gonna skip through. I'll come back to that maybe. Now I'm gonna change gears real quick. Another claim that brokers and any seller of property can get sued on in Oregon is the Unlawful Trade Practices Act, and that's Oregon's Consumer Protection Act. If you buy a bad car from a car dealer, like if you heard of lemon laws, that's where that's at. And then the UTPA also has a provision in there that says any seller of property, broker, or if I sell my house for sale by owner and I misrepresent, I could get sued under the UTPA. And the thing about the UTPA is it entitles the plaintiff to attorney fees. And attorney fees are significant, or I should say, they're important. And the reason for that is sometimes, actually quite often, the attorney fees are going to be more than the claim itself. So if a case goes all the way to arbitration or trial, the attorney fees could be $200,000, and you've been sued for $15,000. So fees are important. Another not so common in Oregon, there's only one reported case of the unauthorized practice of law. Some gal in the late 1970s, she was a real estate broker and went around town telling everyone she was a lawyer and she wasn't, so the bar sued her. Now, any of you practice on the East Coast ever? Or know anyone that does real estate on the? So lawyers are very involved in residential real estate transactions on the East Coast. In fact, closings usually happen at lawyers' offices. And in those states where lawyers are involved, there's a high rate of lawsuits against brokers for the unauthorized practice of law. Now, most of you, whether you know it or not, probably violate this on a daily basis, and I'm not going to tell you to change things up. Just use your discretion. So technically, if your client looks at the title report and says, "What are CC&Rs?" and you say, "Well, they're restricted covenants that govern what you can and can't do on your property," that's technically the practice of law. But I tell you not to answer no. Now, if they say, "What is Article 7 on estoppel certificates in the CC&Rs?" and you don't know, don't make anything up. Tell them to talk to a lawyer. Tell them to talk to me specifically. Just kidding. Okay, now handling claims. If you get an arbitration demand, don't sit on it. That's the worst thing you can do. There's a few ways to resolve disputes in real estate, and it depends on the contract language. A lot of the times, mediation is sort of a first step before you go any further. Mediation is not binding. You don't have to agree to anything. Usually, you sit in one room, the other party sits in the other, and a mediator goes back and forth and tries to resolve the dispute. At the end of the day, if you do come to an agreement, the mediator usually writes it down and you sign it. At that point, you are bound by it. But there's nothing that's compelling you to actually have to enter into an agreement. 3 hours into the mediation, if you think it's unsuccessful, there's nothing preventing you from getting up and walking out. It's not binding. Arbitration, though, can be binding or non-binding. Generally, with real estate in Oregon, it's binding arbitration. So whatever the arbitrator decides is what you live with, and it's treated just like a court judgment. And do you know why all of your contracts, for that matter, require binding arbitration against you if you get sued? Keep it out. Why do you want to keep it out of the courts? The other industry that has that. Did you say cheaper? Yeah, most people say it's cheaper and quicker.
It's just the courts are just so backlogged with all other kinds of.
Not that bad. No, the reason is, there's no public record of
We
it.
don't want a jury trial.
And you don't want a jury trial
There's no public record of it.
of arbitration now. But yeah, no, the public doesn't like realtors. You don't want a jury of your peers. The public hates lawyers even more, but they generally don't like realtors.
That's a catch-22.
Yeah, I know. Now, as far as cheaper and quicker, I disagree with that, although that's what most people still think. The last arbitration I was involved in, it was a panel of 3 arbitrators. It settled before arbitration, but do you know how much the arbitration fees were at that point? $10,000. So you can get a 2-month jury trial in Washington County for $247. And it's about the same amount of time, about a year. So, no, the real reason is there's no public record. You'll have attorney fees in both. Yep. Yep. Yeah, arbitration, arbitration is just like a trial. It's the same effect. That if you get an arbitration judgment, they can garnish in fact, I sued this broker a year or so ago. She was slick, and I tracked her down, her new brokerage. And guess what? I got her last 3 commission checks. I don't even know why I'm telling you this.
Are we supposed to like you?
No.
Just saying.
No, I generally represent brokers,
Oh.
but I do sue them occasionally. In fact, I'll tell you about a couple of them real quick. One, and you may have heard me tell this story. It was a meth house case in Jefferson, Oregon. You know what Jefferson, Oregon is? Don't ever go there. It's a scary place. My clients found their dream property there. And what's that? Yeah, I know. And so he's an Air Force captain. He's married with 7 kids, and they have family in the area. They sent him to Oregon State to do graduate work, and they were really excited about this property. It has a main house, a giant, I think, 5,000 square foot shop, and then 2 outbuildings. And then it was owned by an LLC made up of a licensed real estate broker and a construction guy. They would buy houses, fix them up, and flip them. So they were just happy that it was a licensed real estate broker that was the seller. Well, it turns out the construction guy took a liking to meth so much that he was cooking it, smoking it, and selling it. And you know the very last question on the disclosures, has this property ever been used as a hazardous drug? Illegal drug, yeah. They checked no.
Oh, my.
And so when they bought it, they pulled up in the moving truck, and so it closed on the last weekend of July. And then the day after, the construction guy, he was living in the crawl space of the house, had a sort of a moment of repentance. So my clients show up with all their kids, and they're like, hey, you shouldn't go in there. It's contaminated. And it was, really. So they lived in a trailer and a tent for 13 months in the backyard. And so they bought the house for $400,000. Do you know how much it costs to clean it? $380,000. So now here's where so I sued the broker and I sued the brokerage. Brokerage said, he was selling this on his own, and that's wrong. In Oregon, if you're a broker, it doesn't matter if it's your own property or not, you are still held to the standard of a licensed real estate broker, and your brokerage is on the hook. But what made them settle is I got a hold. They had listed it and were under contract 2 years before when it was contaminated then. And on that same question, illegal drug site, they had checked NA.
It either is or it isn't.
Exactly. But 2 years later, with my client, they checked no. What's the difference between NA and no? Fraud, yeah. Yeah, well, is it not applicable, or is it you really don't know?
There's unknown.
There's unknown. That's what I meant to say unknown.
Oh.
I'm sorry, unknown. So unknown to me means you have all the information necessary to make that call. Excuse me. If you check no, it means you have all the information necessary and the answer's still no. Unknown is you just don't have the information, you really don't know. But checking unknown and then a year later no, that's to me that was a huge red flag, and it was. And they paid. We settled the day before Thanksgiving just last year. Yeah. So.
The shop and everything he had contaminated.
No, just the primary dwelling. The shop did have some levels, but that was cleaned fairly cheap. But yeah, it was in the newspaper. My name's in the newspaper. No big deal. Check it out. I'm just kidding. So.
Now you're the meth cleanup king.
Yeah, I know a lot about. In fact, I know enough about meth. I could probably cook it myself. But it's scary stuff. For children and elderly, if it gets into the groundwater, it's terrible, terrible stuff. So with your insurance carrier, so if you get sued or you think you're going to get sued, one, talk to your principal broker. I gave this class a long time ago, and I talked about that garden gnome case, and one of the brokers raised their hand and said, similar issue, bird bath went missing, buyer called up, was going to sue, and the principal broker got in his truck, went down to Home Depot, $110 later, issue is gone. Because what you'll find, or what I have found, is people get to a point where they're right on the verge of suing you or just going away. And if you say the wrong thing or you say something flippant, that's going to be enough to trigger a lawsuit. Now, with your insurance coverage, the carrier has two duties. One, to defend you, hire and pay for a lawyer, and two, to indemnify you. So if you are liable to pay the judgment. And they're independent of each other. So if you get sued and you tender the claim to your carrier, you'll probably get a long letter that says, we don't think you're covered. In fact, there's all of these exclusions, and this claim fits into every exclusion, but by the way, here's the name and number of the lawyer. So don't be scared when you get that. It's called a reservation of rights letter, and it's pretty standard. And again, frankly, most of the time, the duty to indemnify is less important than the duty to defend. They're almost always going to have the obligation to hire and pay for a lawyer. One other exclusion is failing to timely tell your E&O carrier about the claim. So if you get served with an arbitration demand today, and let's say you immediately set up a mediation and you're pretty dang sure it's going to settle in a couple of weeks, and it doesn't, and so a month later you tell your carrier's probably going to say, guess what, you told us too late, no coverage. And that is one exclusion where they may not even have the duty to defend you. So your insurance isn't going to get canceled. Your rates aren't going to skyrocket. Don't be reluctant to let your carrier know if you think there's a demand coming. Some other exclusions: intentional acts, violations. Some of the newer policies do not have an exclusion for violations of federal or state law. So, for example, if you get sued under the Fair Housing Act for discrimination, a lot of policies exclude that. False advertising, and then any act of dishonesty. Stealing money, lying, fraud, almost always excluded. Okay, now here's some fun stuff. These are actual cases. So this one, Hodgkins is the realtor. Cousins is the buyer. Cousins is a dentist, and he's looking to buy an office. And he had his eye on this office that he drove by every day. And then all of a sudden one day there's a for sale sign out. So he calls up his agent, Hodgkins, and says, hey, this office building that I really like would be perfect. Will you go figure out what I need to do so I can buy it? So Hodgkins goes down to the office complex, meets with the manager, and the manager says, well, yeah, it is for sale, but it's a package deal. You have to buy that building and the building behind it. And it was a really, really good deal. In fact, such a good deal that Hodgkins and his brother form an LLC the next day and buy both buildings.
Oh, boy.
So a month or so goes by, and Cousins is driving by and sees the for sale sign gone, calls up Hodgkins and says, hey, what's the status on the building I want? He says, it was a package deal. You wouldn't have been able to afford it. My brother and I bought it. So Cousins sues Hodgkins, and Hodgkins loses. So a couple of things. One, duty to present all offers. You're not in a position to know what your clients can afford. Now, generally you have a good idea, but that's not your call to make. Maybe they just got an inheritance and he could have afforded the entire complex. You just don't know that. And then he violated you can't go behind your client's back. Now, And Hodgkins called up Cousins, said it's a package deal, here's the price, and Cousins says that's too expensive. Sorry, fine. Then Hodgkins can go and buy it with his brother.
Does he have to disclose it at that point, that if he doesn't buy it, that Hodgkins is?
I would. Legally, probably not, but again, what's ethical and what your clients think is ethical.
And what if you want to sell him something else down the road?
Exactly. Yeah, if you want to keep that and based on the facts of the case, it sounded like Cousins and Hodgkins, they've known each other for a while. Here's another one. This is down in.
I got a question.
Yeah.
Yeah. Could Hodgins have said, "Hey, I have an interest in this property. I'm going to break my client relationship with you, get another realtor, because I'm going to make an offer on it."
Could if the listing if the contract between Hodgkins and Cousins allowed for that. So in other words, if it allowed for the agent to unilaterally cancel the contract for no cause, and he cancels it, then sure. But actually, I don't know about that.
It's just a buyer. Was there any contract?
Yeah.
I'm assuming he had a
Buyer's
buyer's agreement,
Maybe
but
not.
I don't know. That's probably okay. I'm just trying to think. Yeah, if you cancel the agreement, your fiduciary obligation is terminated at that point. It's probably fine.
Now, if you canceled it, you get the property.
Not if the intent was to go. Yeah, that's a good question.
But it doesn't apply to moving money.
Yeah, I'll give it some thought if I come up with something. So this one, this is in Texas or Louisiana, one of these backwoods states. My brother lives in Texas. I hate Texas. But apparently termite inspections are part of every residential transaction. So Hopkinson represents both the buyer and the seller. That's not what got her in trouble. Texas allows for dual agency with informed consent. So Hopkinson quickly realizes that the whole house is infested with termites and it has damage. None of it's visible though. And she knows this because there was a termite inspection. The report was published and it says this place is infested. But she knows that if she gives that report to Mays, that Mays are going to walk. So she has her friend do what the court calls a drive-by termite inspection, where he literally drives by, produces a report, and says, yeah, it's all good. So Hopkinson has both the reports, gives the second one to Mays. Mays buy. A few months later, they go to redo the floors and realize, guess what, it's infested. And then they find out these two reports, Hopkinson is the hidden one, and Hopkinson gets hit with the entire cost for the termite remediation. It was a couple $100,000. It was structural damage. So. This is another one. This is a log cabin community, I think in Montana. And the buyer and the buyer's agent go in and they're looking around, and you can see water staining in the corners. And the buyer's agent says, yeah, we'll get the inspection and just see the extent of it. The buyer says, I don't want an inspection. I'm okay with a little bit of water coming in. I really want this. And so he buys it. And then a little while later, it rains really heavy, and there's an inch of standing water throughout. And the neighbors all tell him, yeah, everyone knows it leaks because when it was built, the logs were upside down, so they cup water, and then they just spill over. So he sues his broker, the seller, and the seller's broker, and the court comes back and says, sorry, you're out of luck. You waived your inspection. The inspection most likely would have identified that problem. You waived it. You're out of luck. Your misrepresentation claim is gone. So that's the importance of inspections. Here's one, and I did this class about a year ago, and the broker, she used to practice in Malibu and knew every party in this case, and apparently it was in the newspaper. So it's this house in Malibu, California on a cliff. Next to the house is a guest house. And during the inspection or when they're walking through, in the guest house, they could feel that it was sloped, like they were walking downhill. And on the back of the main house, there's netting all the way down the cliffside, so there's rock and debris sloughing off. In most cases, that would be enough to say, okay, the defects are obvious and visible. You don't have a claim if something does go wrong. So they buy it, and then I think a year and a half later, the main house literally slides off the hill. No one died, but literally slides off the hillside. And the buyer sues the realtor, the developer, and the contractor. Now, the developer and contractor were both out of business and bankrupt. So realtor gets hit with this, but here's why the realtor ended up being liable. During construction, the realtor is in the developer's office and sees a report called a geotechnical report for this property. And he's flipping through it, and there's pages of recommendations. Certain type of compaction, filter, shooting quickcrete into the soil to stabilize it. And he says, you know, what's going on with the property? And the developer says, too expensive, we're just going to build. So at that point, Realtor knows of soil stability issues, doesn't say anything to anyone, it slides off, the Realtor's E&O policy gets hit with the entire thing. Yeah, exactly. No, people do. I used to do a lot of construction defect cases. My first case, it was in 2004 down in Charbonneau. It was a condo conversion. And the developer instructed the contractor that when they came across dry rot to paint over it. And the developer had 2 on-site sales agents in that they had a clubhouse. And so we sued the developer, we sued a whole bunch of people. And the last holdout was the real estate brokerage. And a few nights before trial, I was going through documents and I see this note of this gal's name. She was the receptionist. And I found her number and I called her and I said, do you remember so-and-so at this place? I almost said the name of this place. She said, oh yeah, I remember this. I said, oh, this is going to be good. So it turns out every time these 2 brokers sold a unit, they would go into the back office. They had a piece of dry rotted joist that was sitting, and they would joke and laugh that they just suckered someone else into buying a place. Yeah, and the brokerage settled the next day.
What do you think about the state's new law that they're maybe passing about not being able to sue developers having a shorter window?
Yeah, so this comes up frequently, and they do it almost every legislative session. It probably will not pass. I've testified down there a couple times against it. So let me just recap. So there's legislation again this year where the developers lobby has come to the legislature and said, okay, we want the statute of limitations, in other words, the time frame for which I can be sued, to be shortened, which is great if you're the one that's going to get sued.
10 years to 6.
Well, so it depends on the claim. So for negligence, it's usually 2 years from the date of discovery, but no more than 10 years from the date of construction. For breach of contract, it's usually 6 years. So yeah, they're basically trying to cut that in half. Now the architects lobby a couple of sessions ago snuck that in for the architects. So now there's a very shortened statute of limitations to sue an architect. But the home builders, this is probably the 6th time
And
they've
it's
tried.
under the ruse that it'll make it more affordable for them to build more affordable condominium kind of units.
I hope that doesn't happen. I'm paying for my kids' college through all the work I did doing construction defect litigation. But I'll tell you, yeah, the HBA, yeah. But in the peak of the construction defect litigation, the governor, it was Kulingowski at the time, created a construction defect task force, home builders, lawyers, managers, all of this. And they came up with, it was like 200 recommendations. We're talking one requirement that would make contractors do 15 minutes of training to the laborers who install siding, so that when they put the moisture barrier, that it wasn't reverse lapped. You know what I mean by that? It's like if you tuck your raincoat into your pants, it doesn't work. And it literally takes 15 minutes of just showing someone, goes this way and this way. The builders lobby they shot everything down. Oh, we'd rather get sued, have the insurance pay it, and keep on building. They don't want to spend the time to train on how to properly lap. Yeah. Now, last, and then we're done. So this one, agent represents the buyer. There's an inspection. Visually, the foundation looks great. I think it was 3 years later, buyer calls up the realtor, his realtor, and says, hey, there's problems with the foundation. And here's what the realtor says, quote, and the courts rarely quote people unless it's significant. Realtor says it's no longer my problem. Court said, inspection, everything, there was no indication that anyone had any idea there was a problem with the foundation 2.5 to 3 years before. But the court said, the use of the word problem, they say, well, a jury could infer that the realtor had knowledge of a problem. Had realtor said sorry and hung up, it probably wouldn't be a case. And this is back to my point of when you get angry clients or angry folks on the other side of a transaction, just be civil and don't say things that are flippant, because it's those little things that will trigger someone to turn around and speak. And with that, I'm done. Questions?
No, more.
More?
Yeah, why not?
Is this, oh, this isn't a 3-hour class, is it? Yes, ma'am. Sure.
So I represented the buyer, who was in the profession of risk management. And we had inspections, we got repairs done, we got radon stuff put in. Maybe a few days before closing, he's reading through some documentation from the title company that discloses that underneath the vinyl siding is asbestos.
Ooh. That was on the title report.
And so he wants to back out, like 3 days before closing. Could the seller at that point sue him?
Yeah, but I wouldn't, because if I was the buyer, I'd turn around and say, you just tried to sell me an asbestos contaminated property.
Well, the seller had no idea.
Oh, really? Okay.
Oh, no, it was way long time ago that the vinyl siding, or the asbestos had been on there since the 50s. And then later, 10 or 15 years later, the vinyl.
I think, what on earth in the title report would have identified
I
that?
don't know.
Yeah.
I don't know where he got the information, but I disagree.
So how, is it just earnest money that's an issue? Or does the buyer wants to back out?
That's what I don't know, because it's so close to closing, and the inspections have been
Yeah.
done, and all the repairs have been completed. So
If I represented the buyer, I would just send a letter demanding my earnest money back and then walk away. If I'm the seller, I would tell the seller it's not worth a lawsuit. You don't want to be the plaintiff saying that, yeah, I'm not going to give my money back because this stupid guy doesn't want an asbestos contaminated property.
right.
I would, both of them should just walk.
And then the seller's gonna have to.
And then the seller's got, yeah, the seller's going to have to figure out something. You can sell, if you own a house that's contaminated with meth, you can still sell it. You have to disclose it, and there's a separate set of.
But if you don't know it.
If you don't know, you don't know.
Right, the seller didn't know.
But your seller knows now. That's the problem.
Yeah, well, right.
And so now, from here on out, the seller's going to have to disclose that. Now that
Well,
the seller knows.
he had a guy look at it and by the square footage say what, if he ever decided to take off the vinyl and take
What it would cost.
What it would cost if
Yeah.
he decided to go through with the
Yeah.
purchase.
Have your seller
Sold it later
walk away
with
from
that
that one,
still
relist
back.
it, disclose that, and then
Yeah.
take into account in the purchase price the cost to remediate it. So. Well, thank you, everybody. Appreciate it.